paragraph 9. Do you have it?
Underneath.
At the bottom of the page.
Yes, both the first and second respondents.
Both the first and second respondents argued that the application lacked urgency, saying that the applicant did nothing after it received the tender letter on 11 August 2023 and only approached this court on urgency on 15 September 2023. The applicant contended it made a mistake in its founding papers regarding the dates, and the month of September and not August is when the applicant was notified by the whistleblower about the tender. It received the tender letter during September, it approached the legal representatives during September, court papers were drafted during September, and the urgent application was instituted during September. So, if I can explain what's happening there. You launched this application on the 15th of September, your foundation. That's correct?
That's correct.
In a founding affidavit that you signed.
That's correct.
The respondent said, in your founding affidavit, you mentioned that you received the tender letter on 11 August, which means you've delayed for over a month, and it's not urgent, it's self-created urgency. That's what that's what was confronting you.
Correct, correct, Commissioner.
Then in paragraph 10, in correcting the error regarding the month, the applicant in its answering affidavit, it should be the replying affidavit, says, and this again was an affidavit that you deposed to, I apologize to the Honourable Court for the heading before paragraph 22, which reads events of 13 August 2023. In the affidavit I deposed to on 15 September. This was a typing error and was intended to read events of 13 September 2023. I further apologize to the Honourable Court for the referral to the date of 13 August 2023 as appears in paragraph 22 of the affidavit. This was a typing error. It was intended to read 13 September 2023. And then all of the August dates are apologized for and it is said September. Then the judge concludes at paragraph 11, based on the following observations regarding the dates leading up to the adjudication of the application on 15 September, it's in my view highly improbable that the applicant received such an important piece of information in the form of a tender letter, consulted with legal representatives, did everything that it takes to cause the matter to be ripe for hearing by the 14th of August, and thereafter decided to bury his intentions of approaching this court until a month later. Given the chronology of events as they occurred, it's my view highly probable that the events under 22 to 25 occurred in the month of September, not August. So what you were telling the court is that you only got the tender letter and you only went to lawyers in September, not in August. That's what you said in your replying affidavit.
That's correct.
But if we look at the money flows, you'd already had your community meeting, taken a decision to go to lawyers, advanced 150,000 to lawyers by the 10th of August.
That's correct. Commissioners, I'm trying to establish what the SC, the relevance of this.
Don't worry about relevance. Just respond to the questions. We will deal with questions of relevance.
No, to me, SC is adjudicating on a matter that has been decided by the judge now. He's asking question about something that has...
Let me put it to you. What I'm saying to you is you actually lied on oath in your replying affidavit. That these events in relation to the contract that took you to lawyers happened in August. And when you were called upon to explain why you only brought this application on the 15th of September, you lied and you said, well, these events only happened in September.
Yeah, you see, that's the thing, Commissioners, that I will not be understanding what initially what the SC was trying to say. And this happened in 2023. I'm trying to pick up the pieces that you said, the SC said, let me tell you what happened here. And then I've been trying to understand what it is. is an affidavit that was prepared by the lawyers, who at that time were advancing reasons for the late agency application. And according to how SC's leading evidence commissioners is saying, I do not think the events or the money issue here, the payment of money, was the reason we went to court late or something. Because I don't understand how do you say I lied in court when on the basis that I say we had a meeting with the community. Having a meeting with the community, those community members did not sign the matter, was to hear their frustrations, telling us that, look, it is time that the tender must be won by someone from here, and this did not happen. That is the point. So how the money issue got involved, I will need to be explained thoroughly so that I can be able to respond.
So how the money issue was involved was 150,000 rands was paid to the attorneys on the 10th of August.
That's correct.
And on the version that you gave on oath to the court, you only learnt the tender had been awarded to someone who you didn't want it to be awarded on sometime late in September, which I'm putting to you as a lie.
Oh, because of the whistleblower. No, now I get the point. The whistleblower came out that there's a tender that is being awarded. But only the appointment letter became available to be able to attach when you go to court that time. Now I remember. Because of the whistleblower, we heard that there was this tender. Similarly, if you check this Ket Matlala's tender, where I say the source, it was in April. But if you check the appointment letter, I think it was signed either in July or August. But because of information that you will receive it prior.
So you had received the whistleblower's report, and that's what triggered you to raise the money at the community meeting, and then to arrange for the transfer to lawyers on the 10th of August. But you only got the tender award letter much later. Is that what your version is?
That's the version. I remember the events now, that the information came out earlier, and that information came in a form of proof that, look, adjudication has been done, evaluation has been done. I think that even the appointment letter is awaiting signature. And this was not followed. That's now information that you get. And you could not approach court on urgent basis without having anything that talks to that award of the tender.
So you'd heard from the whistleblower, but you hadn't got your evidence?
We did not have evidence.
Because you see, in your paragraph 22, which is quoted on page 18, you say you heard from the whistleblower on the 13th of September, which couldn't be true because this all happened before the 10th of August.
Commissioners, I'm still repeating this. How the lawyer put this thing, he was making sense to the court that time. Because I remember now, the appointment letter for that tender was not out, but information was valid that so-and-so has been appointed.
Mr. Madlanga and Mr. Mokgotsi, I stand by my submission that you're lying in relation to what happened then. You lied under oath then. But I want to put a broader proposition to you, which is your role as an agent essentially makes you a professional liar. You lie as your job. What's your answer to that?
That's not correct, Your Worship. That's not correct, commissioners. Even when I spoke about the legend building and stuff, there's rules. You cannot just stand up and lie. This was a pure community project, and I did not lie. That's why they say they came aware of the timber. There was no way the lawyer could say in the affidavit, we had a whistleblower and therefore the appointment date came late. That's how the lawyer would put his thing to court. So I am not, I will not just lie and I did not lie under oath. It was based on the circumstances that the appointment letter was not present, was not available at the time.
Are you suggesting that you didn't lie to Mr. Madlanga?
That was now is a different case.
But I go back to what I put to you earlier, that your job as an agent requires you to lie for a profession, as a profession.
I may not have a comprehension about lying as a profession. As an agent, you cannot. There are rules. You cannot just lie if you are not in any mission.
And is it a rule of being an agent that you can't lie under oath?
Any matter that is conducted under oath, no one is allowed to lie.
Can I take you to exhibit bundle page 43? Do you recognize that document?
That's correct.
This is the affidavit that you gave to Colonel Schneller in support of the 252A application.
That's correct.
And it's an affidavit. If we go down to page 46, you'll see you signed it in front of a Commission of Oaths.
That's correct.
Can we see what you say in paragraph 1 of that affidavit?
I can see 100% what is
Do you want to read it?
That I'm an adult male employed in government with the Office of Minister of Police.
Sorry, I just didn't get the...
That I'm an adult male employed in government within the Office of the Minister of Police.
Is that true?
It's not true. I have, indeed, even yesterday immediately, I did raise this with the lawyers, that when I introduced myself to Lieutenant Snell, I never told him I'm an agent. And indeed, if you check what I was doing there, he was going to ask me, and he asked me indeed, that how can this man ask promotion from you? Who are you? How is that possible? Now that's how this thing, there's the sentence that says, I'm a male employed in the Office of the Minister. Or else I did not carry the authority to conduct the 252A.
So, Mr. Mokgotsi, are you saying that if you need to lie for a purpose relating to your job as an agent, it's okay to lie under oath?
It's not okay to lie under oath. You inform immediately. Even if Commission can draw attention to this, to the content of this affidavit, where I have requested a verbal, there are other transcripts, where I requested a verbal authority to conduct this operation and being granted, and the content says this person's, the extract, not the transcript record says this person wants you to talk to the minister that at least he become a colonel. Is recorded. There was no way this can be practical to Lieutenant Schnell to say that man asked me to give him a promotion without putting this. This is part of the work.
So you're now saying you did lie under oath by saying that you were employed in government within the office of the Minister of Police. That was false, and you knew it was false, but you thought I needed to do it to enable Lieutenant Colonel Schneller to give me authority under Section 252A?
Because I could not tell him that I'm an agent, yes. This was for the purpose of work.
So when it's for the purposes of work, you're saying you can lie under oath?
The circumstances, commissioners, should allow, like I'm saying, there's no any other example I can give. I'm conducting a 252A here.
Let me give you another example. Assume your handler said to you, it is very important for the purposes of this commission that you tell the commission that General Mkhonazi is a CIA agent. And assume you knew that to be false. Would you then be able to come to the commission and say, General Mkhonazi is a CIA agent because your handler had said, for the operation, it's important for that to happen?
No, those are two different things, commissioners.
Why are they different?
Coming to the commission, you are here to provide commission with information that can help. The moment you lie, the commission will not be able to arrive at any level of assistance, cannot be assisted. There's no way you can be given instruction to come to a commission to lie. It's impossible.
Why? If the intelligence operation demands it, why is it any different from lying under oath in a Section 252A application?
Commissioners, if instruction is to come here and lie, I could rather come here and remain silent. I don't think there's any reasonable agent of the law, agent of the state, who will come and testify in a commission or the court or any court of law and lie. Lying under oath is a crime, and if charged with perjury, you will be, whether you are an agent or you are ever, you cannot
I
lie.
agree with you, it is a crime.
Yeah.
But you have lied under oath in this affidavit that you gave to Lieutenant Colonel Schneller, which is perjury, is it not?
Yes, and Lieutenant Schnell is not the commission. We were executing. I'm saying if this sentence is not part of this, because the content of this affidavit is now, this is what happens. It is reinforced by the recording. The transcripts are attached, where a man says, I want to be promoted to become a colonel. He's saying that. Obviously, a police officer who comes to you, who you come to and say, I need an authorization, this thing must happen now. And remember, when you go to him, you go with a police officer. You go with a police officer who explains to him that this person is going to do a certain process, and this requires authority. Then that is why you will see in the annexures the authority was granted. But this police, the same Colonel Schnell, will not write this affidavit if I say I am Brown Mokgotsi, I'm just a comrade. This man, I promised him a colonel position. The affidavit would not work.
So the affidavit had to be granted, including a lie under oath, so that you could proceed with this operation to run the trap involving the officer who was going to implicate General Mkhonazi and General Kumalo. Is that what you're saying?
No, it was not intended to implicate General Mkhonazi or General Kumalo. It was implicating whoever who was plotting the dismissal. Whoever even if it was Jabu, it should not be mentioned that I went there because I knew this recording is going to implicate General Mkhonazi. No, that was not the case.
But that's not what you said in your original witness statement. In your witness statement, you made absolutely clear that you conducted this operation with a view to essentially ultimately prosecuting General Mkhonazi and General Khumalo for defeating the ends of justice. That was the whole purpose of this operation.
I'm still saying you are correct. Even if it was not General Mkhonazi, even if it was General Jabu or General Ma, whoever who was involved in a particular intention, that was the purpose of this operation.
No, but we're not talking abstract in the air here. At paragraph 36 of your witness statement on page 10, you say, the intention was to employ this person as a Section 204 witness against both Lieutenant Colonel Khumalo, and I think that should be Major General Khumalo, Lieutenant General Khumalo, because you referred to Lieutenant General in paragraph 37, and it was Lieutenant General, not Lieutenant Colonel, and Lieutenant General Mkhonazi, who plotted against Major General Khan with reference to the disciplinary hearing.
That's correct, Commissioner.
So that was the purpose of it. It was
of the operation, yes.
The operation was to end up with a conviction against Lieutenant General Khumalo and Lieutenant General Mkhonazi.
I'm not disputing that. It should not be that I woke up from my house with intention that General Khumalo and whoever must be implicated or somehow. The intention comes from the information as it comes, that here is myself, I have information that General Khumalo and General Mkhonazi are intending to do 1, 2, 3. Then you request an authority to conduct a 252A, and is granted. Now you meet this person. The request, it is done through some channel. Now you meet this person. I'm saying, as an agent, I had to mention this, or else, because I was in work, I was during my time of duty, or else it could not be signed.
So, when you lied under oath in this affidavit, you're saying it was necessary for the operation to continue.
That's correct.
You see, that too is false, because I want to take you to the date of this affidavit. Can you go to page 46? The date of the affidavit is 15 February 2025.
That's correct.
By that stage, the operation had been abandoned. And you don't have to take my word for it, you can take your own word for it.
Yeah, the answer is, Commissioners, you can go to page 52.
Before you go to page 52, go to page 45, the bottom of paragraph 8. Bottom of page 45, paragraph 8.
In the main statement.
In your affidavit, the one where you say you're employed in the minister's office.
Okay.
You say, after our meeting, let's start at 7. Due to a family bereavement, I could not meet with, we won't mention the name, until after 13 February. This is the officer who you're going to use against General Khumalo and General Mkhonazi. I am prepared to assist the DPCI in becoming an agent for that officer to be held accountable for his actions. So now you're going to hold the officer accountable. It's no longer General Mkhonazi and General Khumalo. I'm also willing to testify at any formal trial that may take place. After our meeting, I had been communicating with the officer via WhatsApp, and at one point, I indicated to him that we should rather drop this arrangement he wants, as there were media releases that have indicated that Mkhonazi and Khumalo had placed undue pressure on certain witnesses in the DRC to testify in a certain way against Khan. So you'd already decided to drop the operation when you signed this affidavit.
Yeah. That's correct, Commissioners.
And so lying as to your position inside the minister's office had nothing to do with an operation that had authorized.
That's not correct, Commissioners. That's why I was saying, if you check this thing, the date of where is the extract? the date of the recording, after it was done and been granted the verbal authority. This is it. It's page 53.
So page 53 is now not an affidavit, it's a transcript of your meeting with the SAPS officer who was going to implicate General Mkhwanazi and General Kumalo, and a DPCI, I think it's a colonel, who's going to assist you with the trap.
Commissioners, you see, I think these are the challenges that are there, and that is why it is so difficult in this country. Page 53 shows on the 6th of January 2025, this was, the recording has been done.
I'm not sure that that's a date. Maybe it may not be. It's extremely unlikely that it's going to be a date, because this conversation took place on the 29th of January. But according to the affidavits, that may just be a reference number.
But it's written DPCI inquiry 06/01/2025. And if SC perhaps believe it's not a date, but still I'm trying to say, when we approached Lieutenant General Colonel Schnell, the recording, the evidence was in my hand, was at our disposal. It is him who was not available. That's why I wanted to take you to page 45. 45. Where the Lieutenant Schnell was not available, and I again had a funeral. But it does not take the fact that the recording has been done. And probably we should deal with these matters separately, commissioners. To deal one with the part of the affidavit where it is written that this is what I said is true, I said that, and according to SC, I do not know if the evidence or the evidence that is leading now, is it meant to say we did not record, there is no recording? Because the delays, the fact is there was a recording.
No, I'm not disputing there was a recording. My proposition to you is that the existence of the recording is irrelevant to the fact that at the time that you lied under oath, the operation had already been abandoned.
It was not abandoned. Commissioners, it was not abandoned. The person who had to execute in the DPCI, if he was not available, if you could not find him, it does not mean the operation has been abandoned. The moment when he becomes available, it's a similar thing. When there was a search and seizure, if the police cannot find you, the day they find you, they're going to execute the search and seizure. We had the recording. What was important was to get this Lieutenant Schnell to do this thing for us. And we did it. And I'm saying there was no way this would carry weight if I did not attach this portion. That I say I had to do it, and without it, it wouldn't be valid. It wouldn't really mean anything. Because he would even ask me, how are you going to grant or give this person any position if you are not near the minister?
I'm not going to take this